Sisa Namandje Company being one of the big law firms in Namibia and being a big player in litigation specifically, we recognize that there is a need for skills development. And because of that, this session was organized, and we really want to thank Advocate Maleka for accepting our invitation to come and conduct this training. This training is privately funded by the law firm and Sisa Namandje Foundation Trust. I wish to recognize to that end management of Sisa Namandje Company and all the staff members who contributed to make this a reality. I also want to recognize, I'm sure you have noticed amongst us, we have some senior members of the profession. I just noticed the AG and the PG are in our midst. And I also want to recognize Advocate Griffith Madonsela, Senior Counsel. He's here with us also accompanying Advocate Maleka. Before I introduce our distinguished, highly accomplished trainer for the evening, technical aspects of reviews and tactical consideration for a successful prosecution or defense of review. It is an honor for us as a law firm to host Advocate Maleka, and as I've indicated, we are really grateful that he responded to our invitations. Colleagues, you are really privileged to be here to receive this training at no cost whatsoever. Let me introduce Advocate Maleka. This is a man whose reputation precedes him, which makes it very easy to introduce him. He has been a member of the Johannesburg Society of Advocates since 1989. That's a good 34 years practice as an advocate. And for 21 years has been practicing as a senior counsel. He is also a trial advocates trainer for General Bar Council members. And it was for that specific reason that we invited him to come and share his wealth experience when it comes to training, especially in this field of review. So he's well vested in training, and he's in better position to actually identify the training gaps in our profession, and we will actually benefit from this presentation today. Colleagues, make the best of this session. It's one of a kind, free of charge, and Advocate Maleka is ready to share his experience with you. Advocate Maleka.
I struggle to stand up, and that's a reflection not only of my age, but worthless decades of investment in my profession. And I wonder why Sisa thought it was to choose me to inaugurate this training session. Before I get to the substance of our discussions, I think it's appropriate for me to, by way of opening, acknowledge the presence of so many important leaders of society in Namibia. The program director has mentioned them. Simply wish to add a word of recognition from my side and thank them for coming. I would start by making a public confession that when this idea was conceived with Sisa, I did not know that there will be such a large presence of our colleagues, especially young lawyers. We thought it will be an in and out session of few of Sisa's colleagues from his firm. But it is wonderful to see how this country has invested in young lawyers. And I would like to congratulate not only those involved in that exercise of investment, but also the profession, because it is in the youth that you pick up the pulse of society. If you invest in young people, your future is guaranteed. If you invest in young lawyers, it is guaranteed that you'll produce strong, homegrown talent. And your senior leadership of the profession and the judiciary's health will be guaranteed. And I really wish to congratulate you as young lawyers for taking to heart the very important exercise of training. Simply wish to mark out two important things that you must bear in mind as you progress this journey of legal practice. The first is that you have to be patient, because the results are not guaranteed in one day. It's not that exercise of going to a stock exchange and bet on a share. Better still, thank you. That's how we speak as lawyers. There has to be a lectern in front of you. Or going to bet on a lotto and become a lucky winner of a mega jackpot. The profession requires patience, and it's a long-run exercise. And I think that if you bear those two considerations in mind, you are guaranteed to become a very important contributor to a healthy profession and healthy judiciary, and therefore not invite at all costs and time someone like Griffiths Matonsela from South Africa to try and litigate in Namibia. He's my wonderful friend. And I remember that he and I spent almost, I think it was 6 months, trying to defend then Commissioner of South African Police Service, now Minister of Police, on allegations that were made about his leadership of the police service in South Africa. We failed to successfully defend him before the Board of Inquiry, but ultimately in a review, which is the subject matter for discussion today, we succeeded. And as I recall, Griffiths, that review was not opposed.
Initially opposed, but they relented.
Yeah, it was opposed, but when we got to court, the result was obvious. I did not arrange for Griffith's presence today. Let me make a second public confession. He so happened to be here when I'm here, but like all good friends, we follow each other wherever we are. And the last introductory remark I wish to make is that it's always a privilege to stand before you. I think this is the third occasion I stand before the gallery in this place. On previous occasion, I was looking to this side. I'm not too sure whether it's the east or west, but this time I'm looking this side. I'm not too sure whether it's north or south. Just to not only talk to you, but learn also from your experience, so that our discussions today should not be seen as some form of a speech. It should be a discussion, and feel free at any point in time to intervene, ask questions, and I will step off my little nose that I have cobbled for this occasion. So feel free to ask any pressing question you may have at any point in time. For my part, I will be disappointed if there are no questions, if not in the course of our discussion, certainly at the end of it. So I expect more from you than you expect from me. What I propose to do is to talk about reviews on 3 subjects. The first is to track and trace the philosophical foundation of reviews as a form of judicial process, inviting one arm of government to intervene in the affairs of other arms of government. I hope to suggest to you in due course that the traditional lines of review intervention by the judiciary are no longer the only means of invoking review powers of a court. Matters are progressing to invoking review intervention powers of a court into quasi-private public law relationships, and more recently, into private law relationships, because private sector is gaining far more power than the public sector. More recently, because of the expertise of private power, public entities delegate their public power to private powers. And that is so essentially in generally democratic states which do not have capacity to deliver their services or rely on the expertise of private sector power to assist public entities to deliver their services to ordinary people. So please forgive me if I were to sound professorial by engaging in the philosophical foundations of reviews. But I hope ultimately that debate, in the end, will provide us with a level of understanding so that we protect all of our clients in regard to the exercise of power, be it public or private or a mixture of both. That's the first type of subject I'd like to explore with you. The second relates to the mechanics of review. And there I would like to explore how you can use those mechanics for the benefit of your client, whether you are a litigant who initiated and prosecuted a review, or you are defending a review brought against your clients. There are a number of tactical decisions that arise on that score, which would require the exercise of the better part of your legal discretion, not only in advising your client, but also in protecting his or her interest. And the last subject that I'd like to talk about in connection with reviews is the question of remedies. It is one thing to go to court, plead a ground of review and win it, but in the end up with a remedy that does not talk to the problems of your client. In fact, what we have come to learn is that before you even start thinking about formulating a review application or a review defense, the key thing that you have to think through properly, spend a bit of time on it, is the question of remedies, because remedies are ultimately what your client has engaged you for. There are cases, and I'm running ahead of myself, where a review applicant has won and has persuaded a court that their grounds of review are well-founded. But in the end, the court declined to grant a remedy in favor of that review applicant because the court generally understands that a review is a public law or public/private law remedy of discretion. It can be granted or be withheld from an applicant at the discretion of the court. And so my suggestion is that before you even think of formulating a review application, spend a bit of time to think through the remedy that you would like to plead and prosecute or defend on behalf of your client. And then the tactics go both ways for a review applicant and a review respondent. I'll share some of those tactics with you, and it's a subject matter which I believe will elicit a measure of lively debate as we talk about it. So on the first subject, the question of the philosophical foundation of reviews. Thank you. The traditional justification is that a review is a judicial tool or legal process in order to protect and promote the rule of law in a constitutional democracy. We now know that in the context of constitutional democracy such as Namibia has, the voting population invest a mandate in a political party that emerges successful in elections. And part of that mandate is that the political party concerned will be entitled to exercise public power invested upon it in terms of the Constitution and a number of instruments that regulate the exercise of public power. And part of it will be that the party in government will be entitled to establish its own bureaucracy in order to exercise administrative powers. And it is that body of the wealth of public power which will become the center and front of reviews whenever people get aggrieved by the exercise of that public power. And for instance, if you apply for a license of whatever kind, if you apply for a permit, if you apply for a passport, you may not get it. But if you feel aggrieved by that decision, review provides a tool for you to challenge the exercise of that public power. And in that sense, it is a democratic compromise to promote a rule of law, so that those who exercise the power should know that they must do so within the limits of the law, and they must do so in a manner that is rational and justifiable. So those are the traditional lines of the justification for review on a philosophical basis. The second justification, which is emerging in the context of the constitutional debates that democratic countries are realizing, is that review is an important moderating tool for the exercise of power by one arm of government against the other. We all know that in a democratic country, the principle of separation of power is quite important. That one arm of government does not unduly intrude into the exercise of power by another arm of government, but reviews present an opportunity to moderate the extreme consequences of a separation of power, so that if one arm of government does not properly and legitimately exercise its own powers, a court may, in appropriate circumstances, intervene to correct that improper, unlawful, or unjustified exercise of power. You see the manifestation of the remediation of the extreme nature of separation of powers, generally in the context of exercise of administrative powers. But these days it goes further. Courts may well intrude into the exercise of executive powers where there is a legitimate basis to do so. Even more recently, courts may well intervene in the exercise of legislative powers. I don't want to open up old wounds. I will leave the discussion on that score. I will simply note that courts, especially courts that are active in democratic trends, do generally consider it their constitutional duty to intervene in the exercise of legislative, executive, and administrative powers in moderating this principle of separation of powers. One key question is, who intervenes when the judicial arm of government does not properly exercise its power? It's a controversial subject. I would not get into it. Safe to say that there may well be circumstances where a litigant may approach a court in order to correct excesses of judicial exercise of power. The gateway to review, in traditional terms, and judicial scrutiny in a review process is about the exercise or failure to exercise public power. I've already indicated to you the manifestation of the exercise of public power. It is either legislative, it is either executive, or it's about administrative action. And it is at that level of administrative action that ordinary people feel the weight and burden of the exercise of public power. It is no surprise when you look at the law reports that in every law report you will find at least two or a minimum of two cases on reviews, precisely because it is at administrative law exercise of public power that you would find reviews utilized in order to correct the improper exercise of public power. I'm not going to engage with you on what constitutes the exercise of public power. I mean, we know that courts have grappled with these over decades. I would simply mention three tests which I know that they have been adopted in this jurisdiction. And they were formulated somewhere in Australia, given the transatlantic wisdom they profess to have on this subject. It is the so-called control test. Is the decision maker subject to control by public institutions or public entities? The second test is the functional test. You ignore the actor, who is the subject of the decision sought to be reviewed, and you look at the nature of the function. Is the function public in nature? And if it is, then you may meet that functional test. The last is the purpose test. You ignore the nature of the person or entity. You ignore the source of power. You look at the purpose of the power. And if you meet that test, then you may well convince a court that there is public power worthy of intervention by the judiciary. Those traditional lines of review intervention by the judiciary are no longer justifiable in the light of the modern state that most countries live in, because private sector power is becoming as more powerful, if not even more powerful, than public sector. And the courts are now beginning to grapple with the breadth and length of private power in the course of engaging in review proceedings. I would give you 3 examples of instances where private actors have taken decisions that have become subject matter of review proceedings, sometimes successfully, others not. The first of those instances will be a private actor who exercises a power which has mixed features of private law and public law relationship. Give an example in a moment. Take, for example, the profession to which we belong. I'm told that it is here established by statute, but there are voluntary associations within the statute, accredited by the governing body. But at that level of voluntary relationship, it is exercise of private power. You choose to associate or to dissociate. But once you associate, you're subject to the rules of the voluntary association. But that association has the power of discipline, and it has the power of accepting or refusing invitations. The key question that you will confront, and I'm sure that some of you have confronted it, is whether when you apply for membership and they refuse you, can you challenge the decision of that voluntary association to refuse your membership? Or you are accepted as a member, and for some or other reason, your ethical conduct becomes a subject matter of investigation and scrutiny. Would the rules of the private voluntary association consent, which say that you're not entitled to a hearing, and they can dismiss you, or they can terminate your membership without a hearing, become a subject matter of scrutiny and review? So that is quasi-public power. You'd find generally that those powers of discipline, membership, or regulating relationship as between colleagues are generally formulated through some kind of a code of conduct or are sourced from a statute. And in that context, my suggestion to you is that the bright lines of public and private powers are no longer clear, but a very inventive lawyer may well invoke the process of review in order to challenge the excesses of exercise of private or quasi-public power by a voluntary association. There are instances where you find that an organization is truly private by its nature. And yet, because of some reason, including lack of capacity, that organization invested with the obligations to fulfill public functions and duties. I'm not too sure here in Namibia, but in South Africa, I'll give you 2 instances which I suspect replicate the experiences here in Namibia. We have the so-called Social Security Agency as part and parcel of the social welfare system in a country, and it is regulated by an act of parliament, and there's a ministry established in order to provide those social welfare programs to mitigate the excesses of poverty. But the ministry does not have capacity to go and discharge payment of the grants because you require logistical and distribution capacity. And the ministry went out to tender to appoint an entity to assist it in distributing monthly payments of social grants. And the courts have held, without difficulty, that that private actor, in that case a bank, is fulfilling public powers when it dispenses social grants. And its decisions on that score are subject to review. The second example I can think of is the so-called Gautrain development. I think we all know that when you get to OR Tambo International Airport, there is a railway line that takes you to at least Sandton or Rosebank. That is a project which was conceived by a provincial government, and there was a provincial legislation promulgated in order to give effect to that project. But there was lack of capacity within the provincial government arrangements, and they had to appoint a number of experts and agencies to execute that project of Gautrain. And the number of cases around the decision taken by the consortium which was in charge of that project, which had become the subject matter of review and at times arbitrations. And so it is another example of a situation or arrangement where a public entity invested with original or statutory powers invest them to a private sector so that those functions and duties can be fulfilled effectively and efficiently. And that private sector acquires and assumes the obligations of the public sector, which, if not fulfilled properly, will become the subject matter of review. But there is a third instance which has now confronted us and has become a playground of is in those instances of truly private law relationships, where a private actor takes a decision against a counterparty. And the question is whether or not that decision may be open to review in a manner that a public law exercise of power may be open to review. And I can think of two examples where the courts have grappled with that issue. The one is the recent case of Makata versus Vodacom. You will recall that that's a judgment or litigation involving a very inventive and creative young man who is accredited with the invention of please call me back technology. If you have a cell phone gadget, it is not loaded with airtime, you can't make a call, you can use his technology to dispatch a message to another person and ask them to call you back. And as that person calls you back, the network operator who owns the line that you use to make a call back earns income. And Makate was accredited with the origination of that technology when he was working for Vodacom. And in the end, he claimed money from Vodacom. And Vodacom, over the years, refused to acknowledge his entitlement. But in the end, the Constitutional Court found that he was the originator of the technology and ordered that he is entitled to reasonable compensation. The key question which arose is, in what amount and who determines it? and the Constitutional Court devised a private law relationship of resolving that dispute to say you must negotiate as private parties. If you fail to negotiate an outcome that is successful to both of you, then the CEO of Vodacom will determine compensation payable within certain parameters. Next round of litigation is that the parties fail to achieve successful negotiation. The CEO decided to award what he thought was reasonable compensation to Mr. Makate. And to give an example, the CEO decided an award or compensation in the order of, and I'm guessing now, don't hold me to the figure, but it's an illustrative amount of 20 million rand. And Makate says, to hell with you, I deserve 20 billion rand. And you can see how apart they were. And Makate decided to institute a review to review, correct, and set aside the decision of the CEO because he thought that that was not a reasonable compensation ordered by the Constitutional Court. And review litigation commenced in the High Court. And the High Court found for him and ruled against the CEO by way of a review and re-established the parameters of reasonable compensation via the order of the Constitutional Court. But the point at this stage is that there are areas of private law relationship where courts feel comfortable in intervening. I must not leave you with an impression that that is a well-established jurisprudence in our country. The Makate judgment was argued in the Supreme Court of Appeal only 2 weeks ago by some of the very creative and well-known lawyers. And I confess, Griffiths, that that might not be the end of litigation. It will have to go back, second round, to the Constitutional Court. But again, that shows you that private law relationships are not free from review intervention by the courts. The second example of areas of exercise of private law powers between private law actors, where review powers of the court may well be engaged, are in relation to contractual matters that contain clauses that offend public policy, or clauses that become overburdensome to a counter-contracting party because that party was in an unfortunate bargaining position when the contract was concluded and therefore would have to suffer the consequences of the strong bargaining power of his co-contracting parties. You find that, and please don't, I'm not offending anyone, simply mention it as part and parcel of the reality of our modern state. You find those type of clauses in banking arrangements. None of us have the power to negotiate the terms or conditions of the banking services extended to us by the bankers. You find those type of clauses in insurance arrangements where you are told that regardless of circumstances, if you launch a claim, you must do so within the month of the occurrence of the event giving rise to a claim. And you have to comply with many other things. And life being what it is difficult to formulate a rule which applies in all circumstances. You also find those types of clauses in general credit arrangements where you apply for a loan and you get it. I know that some of the countries have formulated consumer protection legislation. And we have 2 of them in South Africa. I won't bore you with them. But those type of legislative interventions are designed to protect consumers, especially those consumers of credit. But often than not, the loans concerned will contain clauses which deliberately or otherwise deprive credit consumers of the protections they have. And the key question is, if a credit provider decides to withdraw credit or terminate a credit arrangement, can you, by way of review, ask the court to intervene? Courts have grappled with that issue in our country, and some of the courts have intervened. Others sadly have not done that. But the point is that right now, the debate about whether a power is public or private in order to engage a review process and remedy, it is no longer a viral debate. Of course, I'm not suggesting to you that it is not an important debate. It is there, but for a creative lawyer, that debate is no longer essential because courts would generally intervene when there is a cause for intervention by way of review. I will leave you with this thought, that if a client approaches you and is aggrieved by a decision made by a public or private actor, or a quasi-public-private actor somewhere in the middle of the two extremes, do not dismiss the cause of that client because the decision that he or she complains about has been taken by a quasi-public-private actor or a private actor in the true sense of the definition of the person or body concerned. Think through quite carefully around whether or not you can devise review intervention by looking at, firstly, the source of power. Where does the private actor concerned derive his or her power from? Think through about the relationship concerned. What was the nature of the relationship which gave rise to the decision concerned? Was it a relationship based on equal bargaining power? Or was it a relationship which is based on the imposition of power by one against another actor? Think through about the intervention that you seek the court to engage in, given the far-reaching impact of the decision of concern to your client. And lastly, think through about the public importance of the decision concerned, because it may immediately affect your client there and then, but it may have far-reaching public consequences for others of a similar kind down the road. And it may well be that you may want to use your creative skills in order to engage the court's exercise of its review powers, regardless of the fact that the actor concerned and the decision maker concerned is not a true public body or entity. I'm going to go to the next topic about the mechanics of the review. I assume that there are questions, and if there are, please feel free to ask them. The second subject I'd like to talk on relates to the mechanics of review. We know that generally in a review, you start with your founding papers, and there will generally be complaints that are generalized, unsupported by critical evidence. There's nothing wrong in it, because a review provides you with an opportunity to source and extract information from a decision maker. from which you can assess whether or not you should proceed with your review. And it is at that part of a review process that a decision maker is called upon to do two things in general terms. One is to produce the record of proceedings, and secondly is to give reasons which he or she is required by law to give, or absent a legal duty, he or she thinks that they want to give to the court. And therein lies the importance of the mechanics of a review process that raises a number of tactical considerations you would have to take into account, either as a review litigant or an opposing litigant. And the first issue that arises is, what is the record of proceedings? Once you launch your review founding papers, you are entitled as a matter of right to access of record of proceedings and the reasons. The decision maker has no discretion. They are obliged to produce the record of proceedings. The debate always emerges about what is the record of proceedings. A review applicant has an incentive to expand the record of proceedings. They want to get each and every piece of paper which was at the disposal of the decision maker, regardless of the fact that the decision maker may not have looked at that paper to arrive at the impugned decision. The incentive on the part of a review respondent is to contract the record of proceedings and reduce it as much as possible. And therein lies the tension that gives rise to questions of tactics. You may choose as a review applicant to litigate on what should be a complete record of proceedings. And in that context, you start a new frontal debate around the record of proceedings, which acquires a momentum of its own. There are, of course, consequences to it, because once you start that type of litigation, it may outstrip and surpasses your main review. Generally, decisions that are subject to review are often time-based. Take, for instance, an award of a contract. It will be about a project which is time-based and has to be executed and completed. Illustratively, let's say 2 years. If you start a debate and litigate around a record of proceedings in a manner that eats into that, illustratively, 3-year period, by the time you succeed and get it to the main review, the execution of the contract may well have been concluded, and therefore there would be no point in proceeding with review. And therein lies the tactics about how you deal with concerns about the record of proceedings. You would recall that the civil form of litigation we have is divided into two general patterns. One is motion proceedings, where you litigate from the beginning to end on paper. There's no need to call witnesses. And the other form is you start proceedings by way of pleadings, basic structure of the case and defense, and you end up into pre-trial discovery processes, calling for production of documentary evidence, and end up going into court. Witnesses testifies. The judge has regard to all of those materials, pleadings, discovered documents used in trial, and evidence, and decides a case. But reviews are a hybrid form of proceedings which stands in the middle. It helps you as a review litigant to start a case on motion, that is by paper, but affords you the advantage of early discovery of the information at the disposal of a decision maker in order to assess whether you have a good or bad case. It also affords an opportunity to get the reasons. So as a review litigant, it is important to use that hybrid form of litigation to your best advantage. But we know that review respondents are not always cooperative. At times, they don't produce a complete record of proceedings. At times, they don't give you the reasons. And at times, they wish to withhold information on the basis of confidentiality. And the key question is what happens? By the way, confidentiality is not a ground to refuse production of the record of proceedings, but it raises legitimate concerns on how you produce the record of proceedings. So as a review respondent, tactically, I would suggest that you meet your obligations of producing a record of proceedings in full by dividing the record of proceedings into two parts. The non-confidential version, which you give to the review applicant without limitation. And the next is the confidential set, on which you regulate the nature and extent of access to the information, subject to protection of confidentiality. It may be confidentiality of your client, or it may be confidentiality of commercial and trade secrets of third parties who may have engaged in a procurement exercise, and they may have given you as a decision maker the information on the basis of confidentiality. And on that score, you are entitled as a review respondent to produce the record on the basis of confidentiality. That an applicant who may be one of the aggrieved participants in the procurement process must not gain whole access to confidential material. And you may wish to regulate access of confidentiality by calling for confidentiality undertakings, so that if confidentiality is breached, you may well be entitled to sue those who breach confidentiality. And so, assuming there is cooperation, assuming that the record is there in full because it does not have confidential arrangements, or assuming it is there in a divided form, confidential and non-confidential, how do you plead your grounds of review based on the right to supplement your grounds of review? I think tactically you must bear in mind that if there is a confidential record, you're not entitled to mix your pleadings and make use of confidential information to plead supplementary grounds of review in your supplementary affidavit in general terms. You will be required to plead supplementary grounds of review by maintaining and protecting confidentiality. So you will then have to have two forms of affidavit. The one pleads your supplementary grounds without restraints on confidentiality. The other deals with confidential matters. And generally, those would be matters that require the use of experts. And you plead those additional grounds of review through a confidential supplementary affidavit and make sure that you protect it. Lawyers who are cooperating with one another in review process involving confidential information will devise a regime through which confidential affidavits do not form part of the public record in court. There is something called the Crown Court. I don't know if you know it. We refer to it as a Crown Court regime, which is basically a type of confidentiality order determined years ago in South Africa by a judge. I remember Griffith, I think it is Scats. Do you remember him? Scats. He was a judge of the High Court at the time and rose to become a very influential member of the Supreme Court of Appeal. And that form of confidentiality regime order has outlived him. And it is important because it sets out the terms and conditions around how you protect confidentiality in litigation. I mean, to give you the worst example of how Crown Court operates. In court, when you debate, I mean, a court is generally a public place. The public is entitled generally to go into court to hear a case and hear lawyers with forensic skills of persuasion, especially if you pay them. Now, you get to a point where you have to debate and persuade a judge about the cause of complaint or a review defense on matters that are confidential. You're not entitled as a lawyer to breach confidentiality by dealing with confidential matters in the presence of the public gallery. What do? Well, Crown Court tells us that you may have to ask the judge to clear the court and clear the public gallery and allow only persons who have a material interest in the confidentiality to follow the debate. And that's Crown Court for you. But bear in mind those tactics, because generally review respondents have an incentive to try and protect information by way of confidentiality or to refuse to produce relevant information. Simply leave you with this about what is the record of proceedings. Courts have engaged in that debate for so long. But, you know, lawyers have always said that the record of proceedings is every piece of scrap paper that was at the disposal, and I repeat, that was at the disposal of a decision maker, even though the decision maker may not have had regard to it. In South Africa, we have had debates around whether when decision makers retire into their deliberation rooms and keep their notes around what the deliberations are in order to persuade each other, is the record of those deliberations part and parcel of the record of proceedings. I think you know the famous case of the Cape Bar Council versus the Judicial Service Commission. You can follow that debate because though the Constitutional Court attempted to, it did not resolve the controversy, and the debate rages on. There is another judgment of Sun International versus Mpumalanga Gambling Board, where for reasons of perceived accountability, the Gambling Board decided that not only are they going to record their proceedings vocally, but they are going to record them visually. And some of the members were captured on camera doing things that I would not encourage you to do in deliberations. And the key question is whether those visual material are subject to record of proceedings. Hot debate. Bear in mind as a review litigant that you may wish to protect those types of unseemly visual material as part and parcel of the record of proceedings. I would like to end up my views on the second subject around the mechanics of the review by suggesting to you that if you are a review applicant, don't be trapped by the tactics of a review respondent who does not wish to cooperate by producing either the full record of proceedings or a divided, non-confidential and confidential parts of the record of proceedings in time. Because if you were to play into those tactics, your remedy may become ultimately fruitless. I suggest to you, if you're a review respondent, a review applicant, that even with a limited record of proceedings, plead your supplementary grounds of review, but do so provisionally, and make it quite clear that your supplementary papers are provisional, subject to a further supplementation once the debate around the production of the complete record of proceedings take place. So you may wish to engage in two parallel processes. You plead your provisional supplementary grounds of review. At the same time, you initiate an urgent application to compel full production of the record of proceedings so that you preserve the integrity of your review remedies in due course. If that tactic is unlikely to work given the constraints of time, I would suggest that you should initiate an interdict midstream the review proceedings and stop the implementation or effectiveness of the decision that you seek to challenge by making sure that a review respondent does not lull you into a progressive delay for the determination of the main review proceedings. Some creative lawyers, they start review proceedings at the same time with an interim interdict in order to stop the implementation of the decision. Of course, that is a useful tactic, but there is a danger in it. Because if you start that type of hybrid litigation, interdict pending the outcome of review, I think they call it Part A and Part B proceedings, I don't know why, but that's the lexicon that we work with. If you do fail in an interim interdict, the legitimacy about your review becomes questionable. And be careful to start that type of hybrid process, unless you're convinced that you have a strong case. And my experience is that interim interdicts, pending reviews, are generally not treated receptively by our courts. I'd like to get to the third subject, which is the question of remedies. And I've suggested to you that remedies are quite important in review proceedings, because a review is not a remedy of right and wrong. It is not like you go to court and say, the man owes me money and I've established liability and therefore I'm entitled to judgment for payment of money in the amount you claim or are able to establish on evidence. I've suggested to you that it is a remedy of discretion that a court may grant to the right review litigant in the right circumstances or proceedings, and it to be just and equitable. I'll repeat myself. Review is a remedy of discretion which a court may grant or withhold to a right litigant because they, by a right litigant, I mean a person who has the appropriate legal standing to approach a court for a review remedy in the right circumstances. And by that I mean circumstances that engage the court's jurisdiction to exercise its review powers, and for appropriate remedy, which is just and equitable. it does not follow that in each and every case where you establish your ground of review, the court will give you the type of remedy you want. The court is entitled to creatively devise a remedy that it considers just and equitable. And you can see the foundational basis of that remedy. Because once you start review, and absent an interdict, the normal legal position is that the decision you seek to review is not going to stop unless there's an interdict. That decision will be implemented generally unless you have a very conscious decision maker who say that I'm going to stop the effectiveness and implementation of this decision until litigation between us is completed. But generally, absent an interdict, a decision that is subject to review gives rise to legal consequences and is capable of legal implementation. And it may well be that by the time the review proceedings are concluded, there has been a fundamental change on the ground because of the continued implementation of that decision. And so the court is not bound to grant the type of remedy you seek, and therefore ignore the concrete reality that has taken place between the institution of proceedings and the completion of the review proceedings. So that's a foundational basis on which the courts have invested upon themselves the power to grant a remedy which is just and equitable. Now, therein lies the tactics for a review applicant and review respondent. If I were to represent a public entity that is a subject matter of review, the ultimate tactic I would explore is to delay and delay and delay the finalization of the review so that by the time we get to court and my opponent succeeds, so look, the case is moot. There is no longer a need for the court to give judgment because the decision that you seek to review has come to an end, or the reality on the ground has so fundamentally shifted that there's no need for the court to intervene. One of the tactics around remedy, and so I suggested to you earlier that think through about remedy quite properly from the beginning. Now, on remedies, I'd like to explore some well-known, established type of remedies you may wish to invoke in review after you have thought carefully and applied your mind to your client's consent, whether as a review applicant or a review respondent. The first, from the applicant's side of review litigation, is obviously you want to set aside the decision you complain about. You don't want it to exist as a matter of fact and law. You want to set aside. And that's why traditionally we say review and set aside the decision. It may well be that in addition to those traditional lines of remedial powers, you ask the court to correct the decision. And therefore you ask the court to intervene by correcting that decision. Traditional rules of remedy. You may also wish traditionally to say, once you have set aside and corrected the decision, refer it back to the decision maker for reconsideration, providing that as a review applicant, time is on your side. Or you may say those are the traditional lines of remedies, but they're not enough for me. I want special forms of remedy. One of which is gaining traction generally. And in recent times, if you want the court to take over the decision that the decision maker ought to make, and the court substitute its own decision for that of the decision maker. We call it the remedy of substitution. It's an extraordinary remedy because generally reviews are not about takeover powers by the courts. They are about respecting the principle of separation of powers and making courts understand that their duty is simply to supervise and monitor the correct exercise of power and not to take over the actual exercise of those powers. But there are cases where courts may well intervene because there would not be any need to respect the sensitivities around separation of powers. Take, for example, where you're faced with a decision maker who's totally biased against you. What is the point of taking the decision back to them? Or a decision maker who truly has a motive not to properly, faithfully, and in good faith exercise his or her power. What is the point? And so in that context, a court may well say that I intervene, I take over the powers to make the decision from the decision maker and unmake that decision for him or her. But you have to show exceptional circumstances because courts do not likely take over powers of decision makers. The third area of controversy from the perspective of a review applicant relates to supervision. There are areas of the exercise of power where a court may well feel that, but I don't have true expertise to take over the powers of a decision maker, because those decisions are invested in an arrangement, whether public, private, or quasi-public or private in the middle, that requires some form of expertise. And the court, generally, there are general practitioners invested with legal expertise and not technical expertise. And courts would be worried to take over those technical powers of a decision maker. What do? If truly they have to intervene in exceptional circumstances, the court may well devise what we call powers of supervision and create some kind of intervention where the courts would require the decision maker to implement its order by reporting to the court at regular intervals how that decision is implemented in the light of the court's order. We call that structural interdicts or supervisory interdicts. And that is one of the tactical remedial exercises you may wish to consider in case the court says to you, but I don't have the expertise to intervene by way of substitution. From the side of the review respondent, remedial debates and tactics around it are quite interesting. Of course, I said to you, you may drag out the review and plead mootness as remedy. The other form of legitimate remedial tactic you can consider as a review respondent is to plead mea culpa and say, no, I was wrong. But I was wrong in good faith. And you ask the court to suspend its review intervention powers pending a corrective exercise on your part. The remedy of suspension is well known, and courts at times do come to the assistance of decision makers when the degree and extent of the mistake is genuine and reflects an honest but improper or illegal exercise of power. And the court would intervene by suspending the consequences of its decision to intervene pending corrective action by the decision maker. And it's a remedy that we employ more often than not when we find ourselves representing review respondents who, for good reason, made a legitimate mistake. Well, I'd like to make some few concluding remarks, unless there are questions. I think it's becoming cold now. Yes.
Sorry, just on the remedy of suspension that you're talking about, I find it interesting having practiced the government attorney's office, where when you look at or you consulted with the respondent, and in the consultation you discovered that indeed there was a decision that was made wrongly and in good faith. I think the practice that has been there is then you simplify an affidavit where you say, I'm going to abide by the decision of the court. Now, how would that be different to the remedy of suspension?
Yeah. So the starting point is that the remedy of suspension is not to be heard simply because you ask for it. You firstly have to plead it, then provide explanation accompanied by credible evidence why the court should suspend. And generally the lines of explanation would be that it is important to suspend the decision to promote the orderly implementation of government functions. Take, for example, cases where your client has awarded a tender, and the tender relates to delivery of services. Let's take, for example, delivery of water to a community that badly requires water. And a competing tenderer feels aggrieved by that decision. If the court were to interrupt the supply of water by means of review intervention, what will happen is that not only would the tender and the subsequent contractual arrangements be set aside, there will no longer be delivery of water to the community. The key question is, why should the innocent members of the community be affected simply because you as a decision maker have made the wrong decision? You may well wish to say that there are public interest considerations which requires the court to suspend its judicial intervention by way of review, pending a corrective exercise on your part. That may well include re-looking at the competing tenders, reassessing them second time around, and making a subsequent decision informed by the court's deliberations on irregularities or improprieties that may have been identified in the course of the initial litigation. In that sense, your duty as a public entity to deliver services is still maintained. The community still gets the supply of water, and there has not been an interruption of public service delivery obligations. Job, how's it?
May I please
Good
request
to see you.
that the person asking the question stands? We are running a live stream.
Yeah, thank you very much. I'm the government attorney. Yes, we have instances where the record is the applicant have requested that they want all the documents, even so long as they are related, even if they were not considered and not part of the decision making. We find ourselves now in that difficulty to say, but if you are reviewing the decision, it's based on the record of what was considered. Yeah, we find ourselves in that corner. Maybe what our remedy as respondents to such a application, and if the court grants the order, what remedies can we pursue to do that? The second question is the question of functus officio. The decision you are functus, and now the settlement normally is where it's difficult, because the applicant will still pursue that they want a remedy of some type, even if you are willing to concede to say, okay, can we concede that okay, the decision that we're taking can be set aside, and then we come back with that, it's referred back. Sometimes we have difficulties there to convince, because it's outside settlement. Then obviously if you don't settle, then you have to go to proceed to arguments. So those are my two questions. Thank you.
I can see that Asino is a review respondent. His temptation is to produce the record as little as possible. And therefore, it's a difficult one, Asino, but my suggestion is your obligation to produce a record is not limited to information which was considered by the decision maker. It extends beyond that. It includes every other information that was available or was at its disposal. Let me give you an example. We will determine that, or we'll talk about it later on around a very interesting ground of review. You represent a client who invited tenders. And what is placed before your client as a decision maker will be a number of information coming from different sources. It will be the competing tenders from different tenderers. It will be the evaluation exercise by a committee that has expertise on the evaluation. It will be the scorecards that would have been completed by the evaluators. But the decision maker may well wish only to look at the evaluation report and nothing else. Now, the record of proceedings is not going to be based on the fact that you are only going to produce what the decision maker has looked at, and therefore the evaluation report only. Your obligation to produce the record of proceedings would be on every piece of scrap paper that was at the disposal of the decision maker. And you can understand why the record of proceedings has been legally defined that broadly. Because part and parcel of the grounds of review may well be that your decision failed to take into account relevant considerations or took into account irrelevant considerations. And to establish that ground of review, you need to look at every aspect of the information at your disposal. And so generally, it would seem to me that when you're confronted by that issue, you would have to look carefully about what was at the disposal of the decision maker, not at what he or she took into account. As to the question of settlement, it is a difficult one. I really, if you permit me, would like to avoid that issue. But if you press me to consider it, top of my head, I'll say the following two things. It is always advisable whenever you are involved in review litigation, representing your client, and generally, in your case, state entities, to settle if there is no basis to oppose. That type of decision, it is not only important to promote a very legitimate and ethical government, but it's also cost-effective in saving otherwise very scarce financial resources that may be engaged in worthless litigation. And as you know, judges these days don't mince their word. And a critical reflection in a judgment by a judge criticizing you or your client to engage in litigation which is not otherwise justifiable may well affect our careers. So I suggest that you carefully look at and settle. The difficulty, though, is a settlement is a product of compromise. And you can settle. But if it's in the context of public law litigation, often courts would want to exercise their supervisory powers on a settlement. A review applicant also has an interest to make sure that a settlement becomes an order of court. Because if it's a settlement between the two of you, it's just a personal rights and obligation matters. It doesn't bind any other person. Others may even ignore that settlement and go to court and still litigate outside the settlement. So to make sure that the settlement binds every other person, even those who may not be party to a settlement, and therefore becomes what we call a judgment in rem, you would go to court and ask the court to make a settlement an order of court, because the court order binds everyone. So to give that settlement a veneer of a judgment in rem by asking a court to endorse it, courts are often worried, and they look at the settlement in and out to make sure that it meets the requirements of a judgment in rem. And there are cases where courts have refused to endorse settlements, but there are also more cases where the courts have endorsed the settlement. I'm not going to debate and enter into those vexed questions of when a court can or cannot endorse a settlement.
I'll move the mic to the back very soon. Just one last question from the front.
Thank you very much, Advocate. Good to see you.
Good to see you, man.
It's, of course, I don't know whether it's common knowledge that I'm not a lawyer. There is something that is common. They say politics is so important to be left to the politician. But if you live in Namibia now, you now understand that law and the judiciary is more important to be left to the lawyers. I will not go in the details. We are very clear now. That perhaps explains why I'm here. I don't know whether Sisa has explained this to you, and I want also just to say it publicly. Before that important review, when we were suspended and expelled from the ruling party, we were actually the first ones. In fact, there was somebody in Tsumeb who was suspended, and he has been on suspension for about 6 years. No hearing, nothing. his brother got elected to the Central Committee and went to plead his case at the Central Committee. And then his suspension was uplifted, I think after 6 years or so. Now, that important review that we won, it was so important, such that both the ruling party now then started putting their house in order. They now have instruments to be able, there's no stories of somebody who was suspended for 6 years. But also the members, not only of the ruling party and many other political parties, are actually frequenting the courts now because of that importance. So we just want to thank you. The dynamics have changed now. The ruling party is no longer that important, but that important principle remains in review. Now, the last question that I work with lawyers because of my work in activism. This problem that I have, so we are debating with my lawyer. This is actually what happened in one case. A decision maker is given discretionary power. Yeah? So, and they exercise this discretionary power, and the lawyer says, man, there's nothing that we can do because there's just this discretion. Now, this discretionary power that a decision maker says, I'm going to choose candidate A over candidate B because candidate A is taller than candidate B. But that's not the requirement. But now the lawyer says, but I'm actually asking and we're debating. Just because you have discretionary power, can discretionary power be used in an irrational or even corrupt? Like these ministers is on public record that doesn't like you, and because they are given discretionary power, they just said no. Even the objective facts shows that you are candidate number 1 or number 2. But now the lawyer is now saying, but this person has discretionary power. But if you go to court, it seems that this discretionary power, you can just go because I have discretion. Because, for example, in the appointment of boards, it says that the minister is not bound by the recommendation. They run a public process. The minister is not bound by this recommendation. They can deviate. So, because they have this discretion, can they just go and get their cousin and impose them because they have discretion? Now the lawyers then say, because now you complicate it more because you are saying the remedy, without the proper remedy, don't even think about proceeding. So now when you go to the lawyers as ordinary people, we are told, no, this person has discretionary power. What do I do when I'm offended by a decision maker who's given discretionary power? So I can't understand and fossilize in my mind that in our laws, a person can, Sisa, you're not the MC. So, can a person use discretionary power in an irrational? So I must just understand that's the dilemma I'm sitting with.
So, Job, the simple answer is no. Discretion does not mean free license to act irrationally or to act not for a lawful purpose or to act reasonably. And there is lots of talent and brain trust in this country to advise you properly on that score. And I have nothing to add really, except to say that discretion is not the end in itself. It's a means to an end. And if the two don't connect, then generally there will be a basis for legal intervention by way of review. And as for the rest, I mean, I can assure you that courts are active. And where I come from, courts choose leaders for political parties via reviews. You know, the fight in COPE about who should be leader. The fight in Ramakata, who should be the leader. So don't feel affronted by that. And it's a compromise which we as a society in the SADC region have decided that when we have difficult and at times emotively difficult fights, we're not going to engage in fist-cuff battles to resolve those fights. we have resolved by democratic arrangements that the courts must intervene to resolve those debates for us. And that's the simple way review becomes so important, a tool of rule of law. I've got nothing to add really, but good to see you.
And, good evening, Advocate. Thanks for honoring the invite. I'm just going to ask a question, but it's premised on one of the cases that you've done yourself. It's the matter of Minister of Investment Corporate Companies. In that particular case, you were basically advocating to have the court exercise its review powers over the president, the national executive, without even adding them as a joinder to the proceedings. Now, in a broader spectrum of, just fairness and prejudice to the other party, and also looking at the fact that, in the holding of the court in pages 36, it could go to 37, and so the court was very clear to say, listen, all orders that are declaratory in nature should not be done in abstract or in vacuum. And parties who need to be there must be brought in terms of Rule 6, Sub-Rule 2, Sub-Rule 5. Now, in that particular aspect, I just want to know, in your view, do you agree with the full bench court that said that your practice was incongruent, or do you hold a different view altogether? And lastly, is the item about the Gordon case, because you were relying on the Gordon case versus the Department of Health or KZN 2008 case, right? I just wanted to know, what are the peculiar circumstances that you need to plead in order for those cases to basically, to your assistance? Because I think the court basically rejected your argument in that particular aspect. Thanks.
I mean, it tells me that you read the judgment carefully. But I'll come to the tactics in a moment. For those who don't know, there was a fight between Minister Gordon in his capacity as the Minister of Finance and the Oak Bay group of company led by its active actors at the time being the Gupta family around whether or not Minister Gordon has the power of intervention. In the fight, the Oak Bay group of company had with the banks, because the banks were withdrawing banking facilities from that group in the light of concerns that the bank had around reputational damages to them. And under the multilateral arrangements of the financial task force, banks have to maintain a level of integrity relating to know your client arrangements. That's the background to the case. And Minister Gordon sought the support of his colleagues in cabinet, which was not forthcoming. And he approached lawyers, well-known lawyers, to find out what is the solution, because he was put under pressure all the time. And he ultimately got the advice that he should go to court to obtain a declaratory order. It was not a review exercise. And the declaratory order he sought was that he has no power to intervene as a Minister of Finance in the private law squabbles between the banks and the Oak Bay group of company. What happened behind the scene is that the banks decided that that is a matter which cannot be left to a fight between the minister and the Oak Bay group of companies, because they were affected, and decided to apply for intervention. And I was asked to represent Standard Bank. And my advice to them was, look, I mean, it's unnecessary for you to go to court and debate this declaratory order. because the declaratory order is a matter of discretion to the court. You have to create a concrete issue between yourself and a group of companies to invite the court to intervene in a manner that goes beyond the exercise of discretionary powers of a declaratory order. And in that way, we were raising a concrete issue subjected to a live dispute between Standard Bank and Oak Bay, because Standard Bank was withdrawing services, banking services from Oak Bay. And that's how we intervened. The question is, we did not have time, because that meant that we have to start new litigation of our own. And we have to create some sort of a device to make use of the litigation that the minister has started to try and fuse in this dispute coming via the back door. And of course, the court criticized us. They found that it was not necessary on the basis of the facts before them to engage in a declaratory form of relief, because the law was clear and the court was not there to give an advisory opinion. And as for Standard Bank's extended application for relief against Oak Bay, the court said, look, you must go and join them properly. Don't come and tell us with Gordon, not Gordon, Gordon versus MEC for Health in KZN. But that's the sum total of the tactics around that case. We, for Standard Bank, sought to create a live issue that goes beyond the mere discretionary exercise of powers by a court in relation to declaratory orders. Well, as to your question whether I think the court is wrong, look, my first duty is to respect judgments, of course. I'm not one who would say they were wrong and publicly proclaim the futility of my arguments. Our job is to argue cases in court, and when the courts reject those arguments, we even have a high duty to respect those judgments.
Thank you. I'm awfully short, so you won't see me. But what I really enjoy about these events is, the cosmopolitan decision makers and the actors are all here. So maybe Tate Mati or Tate Maleka will save us the respondents, because this talk is really geared to the applicants. Whereas I see a lot of respondents in the room, regulators, I also see the Ministry of Home Affairs and various government attorneys. So I've got one question, one comment really, and I might answer myself on both accounts. But I think my question was, as in-house counsel, should the preliminary assessment of whether to or the nature in which you proceed with review proceedings be twofold. So we conclude in the affirmative that, okay, yes, this decision is reviewable, and yes, they might decide in the affirmative that the decision we made was wrong. And then we look at it to a second leg and we say, but will they be granted the remedy that they wish to be granted? And because they might not, on the basis of just and equitable, we might actually win the second leg. Yes, we'll, get a cost order, but we might be able to pursue the decision that we had in any event made. So that's the first question, might be a comment. And then the second, on the question of functus officio, when we're dealing with matters that are fluid in nature, and I know you made a lot of examples regarding, procurement processes, but we've got other administrative decisions that you've got a lot of moving pieces all simultaneously. How do we address the fluidity without opening the can of worms that relates to new matters and, revisiting old decisions? And perhaps should respondents then explore the option of interdict pending a review? So somebody institutes a review against me. Can I institute an interim interdict? The answer might be in looking at the elements of interim interdict. So I might be answering myself there again, but just a question out the crowd. Thank you.
Yeah, these are difficult questions. They're really complex. And I would do an injustice if I were to attempt to confront them head on and faithfully deal with them. I assume that your first and frontline responsibility is to advise your clients about the effect of decisions that may be subject to review. I mean, one of the things that you may want to consider, again in the context of functus officio principle that you have mentioned, is that if you believe that there is something wrong in your decision and requires correction for the benefit of everyone, including your client, embrace the remedy of review, because it is not dependent upon others instituting reviews against you. You may initiate the so-called self-review and initiate the review all by yourself and ask the court to assist you, because you've taken a decision which is final in effect and therefore you're functus, and only the court can correct that decision to bring about a semblance of regularity to it. So self-review is an emerging form of jurisprudence that decision makers that are properly advised often resort to in order to self-correct their decision. And it's important in that regard to approach a court, because functus officio is one of another manifestation of the rule of law, that you must not be seen to be taking the law into your own hands by taking a decision, having taken it, conceive that it is wrong, and reverse it on your own account. Because there are people who may rely on the first decision that you took and arrange their affairs on the basis that it was a correct decision, capable of extracting benefits from it. So that if you are functus and you believe that there are facts that have emerged since that raises questions around the regularity or legitimacy of your decision, go to court and self-review. And in that way, you promote the importance of faithful and proper governance. Don't wait for others to review you. I hope that I have tried to answer a question, but if I don't, please, I regret the fact that I cannot comprehend the full sum of the difficult question you raise.
I am an administrative body, and I make a decision to investigate. And my understanding is that an investigation is a fact-finding inquiry. Now, the respondent says, I'm going to take you in review. Give me the record, everything that you consider to investigate. It's not a final decision. It's a decision to investigate, reviewable. I hope you're not involved in that case. Not yet determined. It's a decision I made in my old life, but it's still hanging on my head.
Thank you, colleagues, and thank you for braving this uncomfortable weather to be with us. It's one of those important investment exercise by Sisa in order to promote our skill in refining the type of services we offer to our clients. And again, that reflects the type of person that Sisa is. When we conceived this idea in today's discussion, I thought that it was going to be, as I said, an in and out exercise. But I'm truly, truly humbled by the extent of the interest that has been shown in this sort of exercise. And I hope that it continues in months and years to come. Because in the end, and maybe not in our lifetime, you will be proud of the impact this type of an effort would produce. I urge you to keep going. The results are not immediately visible, but the impact of what you do in these types of arrangements is far-reaching and guarantees success. Last word from me is that on both sides of the debate, do embrace the tool of review, because it has important and profound social utility in promoting good governance, at the same time in educating review litigants. One thing I did not mention, and let me take this opportunity to mention it, is this. The production of the record of proceedings is not only there for the benefit of a review applicant, so that they could manufacture supplementary grounds of review at their wish. It is also there to inform them about the legitimacy of the decision made, especially if the record is accompanied by reasons for the decisions, so that you as a review litigant would be told about the timelines of the decision and apply your mind to it in order to assess whether it's a worthwhile exercise to proceed with a review. Because if you're confronted by a record that justifies a decision, if you're confronted by reasons that explain the correctness and justification of the decision, you would have employed a lawyer not worthy of their salt to advise you to proceed with a review. The consequences are far-reaching and often get realized at the end of the review, because a review respondent who has done their job and produced a record that amply justifies their decision will be entitled to ask for serious adverse cost order against you as an applicant should you fail in the end. So, a review is an important tool for both sides of the debate. Thank you for coming, and God bless.